Okay, Rajesh, just text me once we've gone live.
Yes, Shahzad, I'm on it.
Okay, we're live. Thank you everybody for joining us for this eBaithak. It is my pleasure to introduce Prashant Narang, who is Associate Director of Research at the Center for Civil Society. Prashant is an entrepreneur and a lawyer. He has represented clients from municipal courts all the way to the Supreme Court of India. And what he's going to talk about today, making a living on the streets, he has an intimate knowledge of. He has done extensive research in this area, as well as defended street vendors all the way to the Supreme Court. Prashant has finished his PhD, and would you be talking about the PhD as well, Prashant?
This was one of the chapters in my PhD on street vendors and the judicial overreach.
Wonderful, because your PhD was on Article 19.1 on the G, if I'm not wrong.
Correct, right.
Okay, so without much ado, let me hand it over to you, Prashant. Please take it away.
Thank you for the kind introduction, Yazid. So I'm going to talk about street vendors, and the topic, the title for this eBaithak is Making a Living on the Street. So let me tell you a few stories. And my first story starts from 1960. But Anas, are we going to do that icebreaker exercise?
Yeah, so I've sent a link in the chat. It'll be great if we can take a moment to take that icebreaker. Sure. And I'll share the screen, Prashant.
Yeah.
Yeah, can you see my screen? So these are the answers.
Nice, interesting, okay.
Yep. Yeah. So great, yeah. I'll just shift my screen. So everyone has brought something or the other. Now it's the lockdown, so we have fruits and vegetables more. I'll just stop sharing my screen. Yeah.
Yeah. Okay. So I will start from 1960, Calcutta, and there was one a judgment called Sudhi Kumar Banerjee versus Commissioner of Corporation of Calcutta. And one person who had a vacant plot of land, but he was unable to access it, and the way to his plot was blocked because of hawkers. And so he complained. He wrote repeatedly to the police and then to the municipal corporation. He didn't get any reply from the police. There was a reply from the corporation, and the corporation also took up the matter with the police. Finally, he had to file a writ petition saying that the way to my vacant plot is obstructed because of hawkers, and kindly issue a mandamus to the police and to the commissioner of the corporation to make sure that the vendors or hawkers are removed. And in the judgment, the court finds out that the corporation had actually reminded the police 5 times, right from 1955 all the way to 1960. 5 times the corporation reminded the police to do it, and the police didn't even reply to the municipal corporation. And the court, observed, which you can see on the screen, common civility demanded that the letters of the municipal authorities should have been duly answered. In this case, however, the police authorities were being asked to do an act which they are compelled by law to perform and not as a matter of grace. This was one thing. Secondly, the court also found out that the hawkers did not sit there without any permission or without, asking the authorities. They did ask police, and the police approved, right? The police allowed them to sit there. Now, the hawkers didn't know whether the police had the authority or not, but the court found out. It looked at the Police Act and also the Municipal Corporation Act, and found out that the authority was with the municipal corporation. The police actually had no authority to allow the hawkers to be there. And in fact, the police in 1955 created hawking zones for East Pakistan refugees, whereas it was, of course, the police didn't have the power. And when the commissioner of city corporation objected to it, it wrote letters to the police to remove them. The police did not respond to the city corporation for almost 5 years, right? While the court gave such harsh observations about the police conduct, but the court didn't really penalize the police, and we know how it works in the government system. So even if the government machinery is at fault, at best the court would only say something harsh in its judgment, but there is no such penal action against the public officials, right? And of course, then they get away with that. Now let's go to the second case. Second was 1983 Bombay. Now, this union, Bombay Hawkers Union. Can we go to the next slide, please, Shorjo? So Bombay Hawkers Union approached the Supreme Court, and their question was, where are the licensing bylaws? So they were struggling with with the licensing part. So they were not getting licenses from the municipal corporation. So there was Municipal Corporation Act, but under the Corporation Act, there were provisions that said that the commissioner can frame the terms and conditions of the license, right? But what terms and conditions? Where are those terms and conditions? Were there any bylaws? There were no bylaws. So they challenged those provisions in the law, saying that, well, there is no guidance. What kind of terms and condition can the municipal commissioner frame? It doesn't say anything about it. And so then there is unguided, these are unguided provisions, and they challenge those provisions based on the guidance there, right? Now, the Supreme Court does something very interesting, right? Instead of reviewing those statutory provisions based on Article 14, 19, 21, it directs the municipal corporation to frame the bylaws, to frame some directions, and it calls it a scheme, right? And not just that, so it doesn't dispose of the case at that direction. It asks the municipal corporation to submit the scheme to the Supreme Court, and then the Supreme Court modifies that scheme, and then this is the judgment. These are the direction passed. The Supreme Court is actually passing directions. It is framing the scheme, but that's not the only problem there in that matter, because the Supreme Court confuses. There is confusion in that Bombay Hawkers judgment whether the scheme is final or not, because it says both things. It says this is the scheme, but it also says that the municipal corporation will now constitute a stakeholders committee that will go through the scheme and finalize it and things like that, right? So it's not very clear whether the scheme was final or not, one thing. Second thing, because the Supreme Court is framing this scheme by way of a judgment, it becomes very difficult to say whether this scheme can be challenged, can be judicially reviewed later or not. So for example, if the vendors are not happy with the scheme, or they want to later challenge the scheme before the High Court, the High Court, would be very afraid of touching anything or reviewing something which has been created by a Supreme Court order. And there are many problems with this order then, because it takes away the power of, the opportunity. It takes away the right to get judicial review. That's one thing. And second thing is, it's very, very specific. The scheme doesn't have principles. It has very specific directions. For example, it has directions with regard to the size of the stall, the timings of the vending, and so on and so forth, right? And the matter doesn't stop there, because then the municipal corporation does constitute another body with all the stakeholders. And those stakeholders take a long time to come up with another version of the scheme. So ultimately, in 1996, after 10 years, that committee comes up with another version of the scheme, let's say scheme 2.0. Then some stakeholders challenged that scheme before the High Court, and the High Court asked the municipal corporation to submit another, some more recommendations. Let's call that scheme 2.1. Then High Court modifies that scheme. Let's call that 2.2. And then finally, that version also gets challenged before the Supreme Court. So it's a full circle jurisprudence. So first, Supreme Court passes an order, then another committee gets constituted. It takes 10 years. Then that scheme gets challenged before the High Court, and High Court invites another scheme. Then it also makes more modifications in that scheme. And then finally, that scheme also gets challenged before the Supreme Court. So now the ball is back in the Supreme Court's court, right? And then Supreme Court finally comes up with another version, so, the scheme 3.0. And it's almost maybe 15 years have passed already. More than 15 years actually, because that was in 2004 that the Supreme Court finalizes another scheme. Now it's safe that, this is the final version of the scheme. So you see what's happening, but I'll come to the discussion part after I'm done with the third case, or the fourth. Actually, there are 4 cases, so let's go to the third case. And third case is from Delhi, right? So this is about a vendor called Swadan Singh. He was a poor hawker. He used to vend at Janpat, and he had a stall of ready-made garments, right? His problem was not that he didn't have a license and therefore he was evicted. No. So he had a license, but his license was not being renewed. His question was that, look, I had a license. I am applying for renewal. I don't get any reply. I don't know why my license is not being renewed or not being rejected with reasons, but I have no information. I have no clue. So why is it not being renewed, right? And NDMC's reply to the court was, well, he's come to the court under Article 32. Article 32 is, that if any fundamental right is being violated, then you can go to the Supreme Court directly for redressal or violation of fundamental rights. But what is his fundamental right? A hawker doesn't have fundamental right to vend in the street. There is no fundamental right. This was the contention of the municipal committee, NDMC. The question is, this hawker had a very simple question. I am applying for a license, right? Now, this government body, which is supposed to issue a license, and it has been doing that in the past. And also we know that other municipal corporations also across the country also issue licenses, right? And the other part was NDMC said 2 more things. NDMC said, well, he was issued a license. So they conceded that he was issued a license. But their point was, well, he was issued a license for selling peanuts. Why is he selling clothes? Right? And this is also kind of funny. I mean, why should it be specific to a particular commodity? Well, whether a vendor sells peanuts or whether he sells ready-made garments, how should that be material fact? Right? That's one thing. Second is, they say, well, he got a license, to do peripatetic vending, and so he was supposed to be a mobile vendor, but he had fixed his spot, right? So he's now a stationary vendor, but he didn't get license to sit at one particular fixed spot, and therefore he's violated the terms. But the problem here in this matter is, while these facts are mentioned in the judgment, but the judgment doesn't revolve around addressing these issues, right? It doesn't talk about whether the denial or the rejection, or actually there was no denial or rejection because the NDMC never replied to him earlier. These reasons only came up during the court proceedings, it seemed. The court doesn't look at these reasons, or doesn't even bothers to look at the administrative reasons. So, for example, why is the NDMC not replying? Why is the NDMC not deciding? Is there a time frame for deciding license applications? Yes or no? Where are the bylaws to decide license applications, right? Which is the statutory provision? Is it mentioned in the statutory provision about the time frame or not? So, for example, there is a jurisprudence, in our case laws in Supreme Court and High Court, that you have to have some time frame. There has to be some procedure, due procedure that you have to follow, due process you have to follow for giving licenses. Whether there is a hearing, is there an appeal or not? Do you give reasons or not? Do you decide your application? Do you decide the licensing application within some time frame or not? But the Supreme Court doesn't go into those issues, right? Instead, it gets swayed by the reason, by the contention of NDMC. Oh, well, vendors don't have fundamental right, and the court gets confused with that. Because there was another judgment called Pyarelal of 1967 or 70 that held that vendors have no fundamental rights. And that's a very problematic proposition, because nowhere our constitution excludes anything from 19(1)(g). So 19(1)(g) says that you have right to pursue any profession, trade, occupation, and business. And it uses 4 words, not just 1 word, right? It uses 4 words to cover all sort of commercial activities possibly that it can. And so therefore no activity is excluded from its purview, right? And therefore this is the reason why it uses 4 words to be as exhaustive as possible. So any activity which is a commercial activity which involves some sort of consideration and exchange of goods or services is possibly covered in 19(1)(g). And so an Indian constitution, unlike the US constitution, there's a difference there, because our rights are not constricted. We have we have the right to pursue any activity, and the state has the right. So first of all, our right, the constitution doesn't grant us this fundamental right. It gives the right to the state. It only announces, it only declares that we have the right. It gives the right to the state to restrict our fundamental rights in to a reasonable extent in the general public interest. Okay, so which means that if the state wants, it can restrict any economic activity. It can restrict your fundamental right to pursue any profession, trade, occupation, or business in the general public interest. Now, the question is, if that is so, then there is also a fundamental right to vend in the street, because there were other judgments, for example, Sagir Ahmed in 1955, which says that the state doesn't own streets, right? The streets belong to the public, and the state at best is a trustee of the streets, right? So it has to maintain streets. It can regulate the traffic flow or other uses of the street, but it can't really say that, oh, the state belongs to the municipal corporation, and therefore the municipal corporation will allow or will give permission to someone to be able to use the streets. So everybody can use the streets. Well, can you use the street to vend in the street or not? Can you use the street for other private uses or not? That's a question, and that you can reasonably restrict. But where is that restriction? But that question the court doesn't ask. Ideally, the court should have asked the NDMC that show us the restriction. Is there a law that you have promulgated? Is it written somewhere that the street vendors cannot vend in the street? So it doesn't ask that question, but it jumps to the question that where is the fundamental right? Is there a fundamental right or not? And it constitutes a constitution bench, 5-judge bench, to decide whether there's a fundamental right to vend in the street or not. Ultimately, it comes up with the conclusion that yes, there is a fundamental right, but all the writ petitions. So Southern Singh writ petition was not the only writ petition. It was a batch matter, and there were number of writ petitions, all street vendors. So the Supreme Court initially said that once we decide whether it's a fundamental right or not, after that we'll form a division bench to look into individual petitions, right? However, we don't find any further judgments related to this matter in 1990 or 91 which involves individual cases. In fact, the later judgments record that all these street vendor writ petitions were forwarded to a Lok Adalat in 1990. And this Lok Adalat was chaired by a retired Supreme Court judge and a retired Allahabad High Court judge, which is very, very unusual, right? It is frustration of fundamental rights, because nowhere in this, Part 3 of the Constitution, it is said that in case of violation of fundamental rights, you can forward this to a Lok Adalat. This is bizarre. right? So Supreme Court not only abdicated from its role, but it also expressly violated Article 32 by forwarding all these petitions to a Lok Adalat. Now let's go to our fourth case. The fourth case is very interesting. Again, this is from Delhi. This was between 1990 to 96, and this is about Vishwanath Roy. Shorchu, can we have our next slide, please? So Vishwanath Roy was a roadside tea vendor, and he wanted to switch over to a garment business, right? And he applied to New Delhi Municipal Council for permission to change his business. The problem is that the Supreme Court, and the earlier three cases are just illustrative cases because once the Supreme Court started intervening in street hawker matters right from 1985, then many more cases started coming up. And since the Supreme Court jurisprudence was now going to be based on passing directions, so more and more cases started coming and it started passing directions. And one of the directions that it passed after Sodan Singh case is to constitute a committee headed by a retired judge called Thareja, and to implement his directions and to do survey of the street vendors in Delhi, right? So Vishwanath Roy first approached NDMC to get permission to switch over his business. And if you remember, we just discussed Sodan Singh case. NDMC's objection is, why is Sodan Singh not selling peanuts and why is he selling garments? So of course, this is not surprising that Vishwanath Roy also had to seek permission from NDMC to change his business from tea to garments. But NDMC raised its hands. He said, we can't help it. We can't take decision on your application because currently, the current regulator is the Thareja committee, Supreme Court appointed committee. We can't put our hands on it. You have to go to Thareja committee. And so Vishwanath Roy goes to Thareja committee. Thareja committee, takes his application, and Thareja committee is writing a report to be submitted to the Supreme Court. It also places an application in the report, his arguments and what is to be done. And then finally, when the matter gets listed before the Supreme Court, when the report is submitted, then that application also comes before the Supreme Court to decide whether Vishwanath Roy can change his business from tea to garments or not. And the court first goes through the report, and the report also mentions Vishwanath Roy's case, which says the report basically notes down that the NDMC cannot have absolute discretion. It has to have some sort of pointers. But precisely this is what it is all about, right? So right from Bombay Hawkers Union, the whole point is about where is the guidance, where are the parameters, how does the municipal corporation supposed to decide on what basis, whom to give license, whom not to give license, what is the parameter to decide whether a street vendor should change his business from X to Y, what is the basis to decide, right? This is the exact question which Thareja committee also hints at, but the Supreme Court again abdicates. Right? Supreme Court says, well, there has to be reasonable restrictions, so NDMC can take a call. This vendor can change his business, and from now onwards, NDMC can take a call whether to allow and how to allow, but the restriction has to be reasonable. Well, that's there in the Constitution that the restriction has to be reasonable. But you tell them, no, ask them that what is their criteria to judge, and where is that criteria written? Is it written in the law? Is it written in a statute, or is it written in some bylaw? And whether that bylaw, gets its power from a written statute or not. But Supreme Court doesn't discuss this question, and this is the most problematic part about this whole 25 years of, or more actually, of jurisprudence of Supreme Court. But 25 years, if we calculate it from Bombay Hawkers Union to Maharashtra Ekta Hawkers 2013 judgment, almost it was 25 years that the Supreme Court was the self-appointed regulator of street vending, at least in two cities, Delhi and Mumbai. Right? So Supreme Court did not do its duty of doing a judicial review of impugned statutes, laws, or bylaws. Instead, it was making bylaws in form of schemes. It stepped into the shoes of the executive and started making schemes and passing directions for almost 25 years. So by 2007 and 2010, if you look at those orders, Maharashtra Hawkers orders, it becomes clear that by 2007, it started realizing that there is a problem. It can't handle all of that. In 2010 to 2013, also it becomes very, very clear when it starts ranting about that how there is no law and it has to jump into passing directions, but it can't do that. It's not viable and so on and so forth. But that's not right. Legislative void is not a good excuse for the Supreme Court to pass directions because there was no legislative void. There were those provisions. Those provisions were bad, but the Supreme Court should have ideally said, should have ideally pronounced its judgment that it is bad. It should have reviewed those laws, on 19, 14, 21, what you have. It should have done that to say that these laws are bad, and that was its constitutional duty. So it abdicated from its constitutional role to encroach into, basically what it did was encroachment. Sorry. Switch on my laptop. So what it did was encroachment encroached basically and got into the role of the other organ of the state. And you see, it's ironical because often the state bodies evict vendors saying that vendors encroach public space, right? But we have our judiciary, which is itself is encroaching and violating separation of powers. It is encroaching the domain of the executive, right? And the body which itself is an encroacher is supposed to decide whether there is encroachment or not. So ironical. Okay, so Anas, can we take questions?
Yes, I'll just share my screen. I've also shared on the chat the link to ask questions.
Anas, when you have time, can you also share that link on the YouTube channel? Because there are a few people watching it on YouTube as well.
I'll do that as well. Yep.
Thank you.
So here are the questions, Prashant. If you can see in the screen. Do you want me to read it out for you?
Yes. So yeah, if you can, or I'll read it. So let's look at the first question. The first question is, are the bylaws and relevant schemes advantageous to the independence of hawkers? If not, what can the public at large do
to ensure
their rights? Okay. So, the first part of it, the first half an hour, I wanted to talk about the history of, the legal history of street vending, of the regulations. Now the situation has changed, and I'll come to that at after this question and answer session. So we'll look at it now. What are the current the regulatory regimes? So now we have a federal law, and we can discuss the law after this question and answer session. Okay. Second question: how does one achieve a balance between street vendors' right to vend and residents' right to have a clean and walkable street? Absolutely. Again, I'll come to this question in a bit. Number 3, what are your views on judicial activism in light of street hawkers? Yes. So, as I said, this term actually, I have a problem with this term of judicial activism. So it is because judicial activism gives us this perception that the judiciary is doing something extra. It is doing something more to ensure justice, right? And this is the popular perception of the Supreme Court judges. You talk about judicial activism, and immediately you would start getting pictures of Krishna Iyer and Bhagwati and so on and so forth. But look at these cases. This is not just judicial activism. It is judicial, it is encroachment, and it is also judicial abdication, because judges are not doing what they're supposed to do constitutionally. It is their obligation under Article 32 to judicially review if any citizen challenges a statute or a bylaw, any law, then it's not discretionary. It's not an option for the Supreme Court judge to say, well, we will see, whether we want to or we don't want to. There's a constitutional obligation on the judges to review it judicially under Article 32. And you look at the language of Article 32. It uses the word guarantee, right? It doesn't say the Supreme Court may or might or something. It says Article 32, the right to recourse is guaranteed in under Article 32 if there is any fundamental right violated, right? So it was judicial abdication and not judicial activism. And it's utterly shameful, because you read Bombay Hawker's judgment and you will see Justice Y.B. Chandrachud says that you have to come to a table to discuss this scheme. But why do they have to come to a table to discuss the scheme? They are challenging the wires of Article Section 313 and 313A and 314 of Bombay Municipal Corporation Act, and you decide whether that those laws are constitutional or not. Right? But it forces the street vendors to come to a table and negotiate the scheme, and ultimately they end up accepting a scheme which doesn't have principles. It's a very, very specific scheme. So if you see it from rule of law perspective, the entire jurisprudence is an utter violation of separation of powers, but also violation of the rule of law. Yeah. Okay, next question. The judiciary is construed as the most progressive institution in our government. Given an unaccountable executive, what are the alternatives we have? Yes, so if the executive is unaccountable, the judiciary has to make it accountable, but doesn't have to, become the executive on its own. So if the executive is not working, doesn't mean that judiciary will run the municipal corporations in Delhi and Mumbai. It doesn't mean that the judiciary will become a super regulator of street vending in Delhi and Mumbai. It doesn't mean that the judiciary will regulate forests in our country. It doesn't mean that judiciary will become an environmental regulator in our country. So you review the law, you decide whether the law is administrative right or not, whether there is due process or not, whether the law is constitutional or not. But the judiciary can't start making laws and can't start implementing the laws, right? That's not a substitute. That's certainly not an alternative. As long as, this would be, and we see this here, that it's a very, very bad alternative. And even if we have to search for alternatives, we search for alternatives within our constitutional scheme. We search for alternatives to find out, to see how we can make our legislature accountable, how we make our executive accountable, and how do we, push for the best practices in governance. But to push judiciary or to get judiciary to run the legislature and to run the executive, that is absolutely not an alternative. Absolutely not an alternative, because judiciary doesn't have the expertise to do that. And there is conflict of interest, because if judiciary starts making those laws and rules and schemes and start implementing it, then who would do the judicial review? And this is the problem you see in Bombay Hawkers Union, because once you pass the judicial directions, right? How do you tell, who do you tell that these directions themselves are not good? They may be violative of 19(1)(g), right? So for example, Supreme Court says you can't cook food roadside. Well, who decides that? How do you decide that you can't cook food roadside? Those people serve food, and there are governments, by the way, if you have seen Jan Ahar rallies, in all states you have canteens and you have carts run by the government, providing 10 rupees a thali, 18 rupees a thali, 20 rupees a thali, or 1 rupees a thali, whatever it is. But government, funds canteens or thelas or small carts or vans which are roadside, and they cook food. And the judiciary is saying you can't cook food. Under what law? Legislature hasn't made any such law which prohibits cooking of food roadside. So who is judiciary to do that? So where will you challenge that law? Where will you challenge that direction? This is very problematic. There is conflict of interest. There is violation of separation of powers, and judiciary doesn't even have the expertise to decide that, right? So very, very problematic. Okay, next question. What are some of your suggestions for judicial reforms in light of the current discourse? This I am this will be slightly outside our domain about judicial reforms, but I think we must have a very robust criticism of the judgments like these. So the problem is, we are very, very end driven. We think, oh, because this is public interest litigation and this comes up with good intentions and this is going to do good, and therefore it's okay if they haven't done judicial review. It's okay if they haven't done judicial scrutiny of the legislation, or if they haven't done due process, or if they haven't themselves followed the constitutional procedure. So for example, sending the writ petitions to Lok Adalat, right? Suppose if the consequences were good, we would have been praising it. So you look at Vishakha judgment, but I think the criticism starts with Vishakha judgment. Our constitutional scheme says the judiciary has to do judicial review, and it doesn't say that it can make laws. And so any deviation has to be criticized. And we have to be very, very focused about the means and not about the end. Just because judiciary does something laudable by encroaching its domain, it doesn't justify that, and it shouldn't justify that. So we have to be very, very cognizant of that. Next question. Do you think the SC acted in an elitist way when it didn't fulfill its obligations? Yes, I think so. But more than elitist, I would see it in a frame of the rule of law and formalism. So I believe that the court should limit itself to its constitutional duties and not violate what is enshrined in the constitution, not overstep its limits. So I would rather see it in that frame. But this is right. If you look at the kind of directions they pass, if you look into the substance of the directions they pass, indeed it is a very, very elitist frame. Especially one judgment was, I think, Sudhir judgment by the Supreme Court in 2004, where the court has used derogatory language for vendors, and it is very, very clear that court seems to have an anti-vendor mindset. Here, I would also like to mention one thing. A lot of criticism that you see from other legal scholars tend to be focused on whether the court is pro-vendor or anti-vendor. Here, I disagree with them. I disagree with all those legal scholars. I think even when the court sounds very, very pro-vendor, and the court comes with very benign, very benevolent intentions, it doesn't do good to the vendors, right? It doesn't do good to the vendors, because the kind of direction it passes, it ultimately leads to a lot of problems, even for the vendors, right? So I would be very wary of any kind of, even the benign activism, even the pro-vendor activism, which is situated outside the constitutional obligations, which is situated outside the constitutional procedures. So I wouldn't endorse any of those actions. Okay, next question. What are some of the more important laws and case laws which are applicable to street hawkers? So law, we will talk about the federal law, 2014 law in a bit. Case laws, so after Sodan Singh, there was Gendaram and also Maharashtra Ekta Hawkers Unions. And these case laws, I should definitely mention this, that these are not adjudicatory cases. It's not that there are two parties and the case actually decides about the rights and liabilities of parties. No, not even the judicial review, not even about whether the law is constitutional or not. No, these cases are essentially all about managing street vendors, about regulating street vending and passing specific directions. How many zones will be there in Mumbai? Will it be 488 zones or 137 zones? How many street vendors will be licensed in Mumbai? Will it be 1 lakh vendors? Will it be 38,000? Will it be 15,000? These are the directions that the court is passing. Okay, next question. Street vendors surprisingly isn't organized into the formal tax structure. If the government is interested in getting more revenue, why don't they streamline its operations? Yes, so that's a good question. I think the answer is in the institutional analysis framework. So who is benefiting by keeping them in the informal sector? And I can discuss it after this question and answer session. Next
So we
question.
move on to the main session and take more questions later.
We have, I think, 3-4 minutes. So at 5:45, we can move to our next session.
Okay.
Yeah. Are there any more questions? Yeah. How can the judiciary be nudged to perform its constitutional duties with regard to street vendor rights? As I said, so this whole thing started with the PIL phase post-emergency, and the court started taking liberties. So I understand, relaxing the rules of standing, that was fine. So you are, for example, accepting, let's say, chits and letters from the most marginalized people who probably may not have access to justice in that sense. For example, prisoners. That's fine. So procedurally, you have some sort of leniency, but substantively, showing, compromising with the judicial procedure or judicial reasoning, or even the constitutional rights, I think that's very, very problematic. And we need to have a robust criticism of this judicial leniency and judicial application. What, according to you, could have been interpretive mechanisms what according to you could have been differently done by the judiciary than the judiciary creating rules and regulations? So judicial review. So they should have reviewed those statutory provisions that the vendors had challenged. So there are two ways. One is challenge the provisions on the basis of constitutionality. So for example, in case of Bombay Hawkers Union, they challenged the law based on the constitution, saying, or even for that matter, that those legislations were very, very vague. How do you differentiate between the vendor who you are going to give license and who are you going to reject? Right. So what is the basis? So Article 14 as well as 91G. What is, how do you say that something is reasonable? Where is the restriction? So they could have done judicial review, and same for Sodan Singh. They should have judicially reviewed it. Okay. The purposive approach and other interpretive mechanisms have always granted certain lawmaking powers to the judiciary. When do these become overreach? No, I don't agree that this is about purposive approach and about. So purposive approach is when you have, 2 or 3 possible interpretations of a law, and one particular interpretation would lead to an absurd outcome. And there you would opt for, or you would choose the other interpretation, which is probably not literal, but leads to a more rational interpretation, rational outcome. But pure purposive approach. So for example, just because, this is the intention of the law, so let's go with that. I don't agree with that kind of interpretation. And that interpretation is absolutely end-centric and not means-centric. And this is absolutely antithetical to the rule of law. And I also believe in what Gandhi said about end and means. So, if you run after end, you will have nothing. Either you will have means nor you will have end. So you must protect the sanctity of the means, right? And law is all about means. Law is not about end. Judiciary cannot foresee what is right and what is wrong. Right? What policy is right, what policy is wrong. In fact, this is why there is separation of powers. There is a rationale of separation of powers that the judiciary, without looking at the policy ends, it has to look at and adjudge the means of reaching to that end on the cornerstone of the fundamental rights. That to what extent these measures, these laws are violating the individual rights. So the first duty of the judiciary is to protect fundamental rights. Judiciary shouldn't be bothered about the ends. The first duty is to be bothered about to ardently protect citizen rights, fundamental rights. That it has forgotten, absolutely forgotten. Okay.
So can we move forward, Prashant?
Yes. Now we should move forward. It's 5:45.
Yeah.
Okay.
So yeah, I'll just print screen again.
Yeah. So now I come to 2014. So the last order, which was passed in 2039 September 2013 in Maharashtra Act of Hawkers Union. And Supreme Court says, well, by then there were two policies, national policies. The government came up with, the central government came up with national policy for regulating street vending in 2004 and then again in 2009. Supreme Court kept saying, well, there is no law, and this is why we have to step in, but it's getting out of control. We can't manage all these petitions because you see, for example, like Vishwanath Roy had to go all the way to the Supreme Court. So all these individual street vendors, hawkers, their unions, associations were approaching were directly going to the Supreme Court. At some point, Supreme Court prohibited the high courts to entertain any petitions because then the petitions will ultimately go to the Supreme Court. So Supreme Court had become the singular regulator, like a super regulator of street vending. But by 2010, 2013, it realized that, and it said that, okay, all municipal corporations should now implement 2009 policy and let's deem it to be the law. So 2009 policy, it's deemed to be the law and implemented, and they passed long directions in 2013 order saying that this is to be the law until there is a law passed by the parliament. And it gave directions that, parliament should come up with a law within 1 year or until it comes up with a law. This is now the law of the land. Okay, all of that. And meanwhile, the central government also had created a model act. Now, the problem is street vending is a municipal issue, right? In our constitution, there are three lists. One is federal list, one is state list, and one is concurrent list. The entries pertaining to street vending fall in the state list because it's a, it deals with municipal corporation and their jurisdiction and so on and so forth. So it falls in the state list. So central government couldn't have done anything much. So it created a model bill and it forwarded to the states, suggesting them that if you want to enact a law, here is your, sort of a model, and you can tweak it if you want to, but you can pass this law in your legislature. I think only 5 states passed their state laws. Most states didn't. The street vendor unions, NGOs, they started pressurizing the federal government, the union government, to pass a law. And the union government then started, first of all, it had to, check whether it's possible for it to pass such a law or not. And so, it sought to justify under, I think it was entry 5 and 23. So basically those entries pertain to social welfare of employees and labor and so on and so forth. Now, this is a very forced or, very compromised justification, very loose justification, because street vendors are not really labor or employees, right? And if you look at the Street Vendor Act 2014, it's not primarily about, the pith and substance of this law is not about social welfare. It's about licensing of street vending, right? And the title of the law also very clearly says, it says protection of livelihood and regulation of street vending act, right? So if it is that, then it doesn't really clearly fit in those, but since nobody challenged it, and I'm sure because again, purposive interpretation, we are all very fond of. So I don't think so that the court is likely to strike it down. So the union government proceeded framing the law. It held consultation, also invited comments from the state governments. And finally, in 2014, they passed the law. In fact, this 1st of May, today is what, 3rd of May. So day before yesterday was the 6th anniversary of the notification of Street Vendors Act, right? So it's been 6 years. Now, the first question is, why do we have a law specifically for street vending? According to me, this is also a violation of the rule of law. And the principles of rule of law is generality, Generality would mean Article 14, equality before law. So as much as possible, we should not differentiate between citizens So for example, a citizen, let's say a citizen who is parking his car in the street, and a vendor, a person who is walking, both are using the street. So I am parking my car in the street, and that's my private use, right? But I'm occupying public space. Same for the vendor. That's his private use in the public space. We have a law to regulate street vending, but where is the law to stop me from parking my car in the public space? So I'm sure, some of you would say, well, if you park your car out the road, municipal corporation will come and traffic police will come and tow your car and take it away and you will do challan. Right. But people who are from Delhi, at least I know about Delhi, I'm not too sure about other cities. So you look into the residential areas, right? So if you look into the residential area of Delhi, all middle class people in RWAs, in residential localities, we all park our cars outside our houses, right? Now, I see a comment here which is about because street vending is commercial. Well, if an activity is commercial, maybe you can tax it, you can charge a fee because it's commercial, right? But both occupy spaces. Who decides who would occupy more space or less space? Who would decide how many cars can be occupied? Who decides all of that? So then these questions, and I'm not saying that the car parking is the only use. What about, for example, processions, barats? And we know in Delhi, for example, again, when there are muhurats, there's shubh muhurat on a particular night, the entire roads leading to the farmhouses are jammed. Why? Because there are hundreds of weddings taking place in farmhouses, and those barats occupy the public streets and they jam. But do you have any kind of permission mechanism for barats? No, there is no permissions for barats. What about scaffoldings, construction? So while undertaking construction of buildings, often builders put up scaffolding, and those scaffoldings are not limited to the plot of the plot under construction. It usually extends to the public space, right? Do they take permission for that? Do they pay money to the municipal corporation for that? Is there a licensing for that? Also, we all use public space in many other ways, right? Religious processions. All religions have their processions, and there is a sort of a common law right. There are judgments that say that there is a common law right to hold a procession in India, right? So these are all private uses of public spaces, but this law is specifically limited to regulation of street vending. Now that's also somewhat problematic because this law envisages a town vending committee, which will have 40% of street vending representatives, and this town vending committee will make a plan and conduct a survey and then license the street vendors. So I agree, there are RWAs, there are different stakeholders. For example, there are residents welfare associations, there are shopkeeper associations or market associations, there are street vendor unions, there is traffic police, and of course, all these stakeholders are also represented in town vending committee, although the majority, 40% of it is street vendors. But who represents pedestrians? Right? Where is the pedestrian union? There is no pedestrian union. There is no pedestrian association, right? So if you, for example, my office is 7 minutes walk from my house. I live in D block on Hoskas, and the office is in A block Hoskas. And this 7 minutes walk, if I see, so it's not just the street vendors, but RWAs, the houses, they have put their security guard cabins on the footpaths. They have also put their bigger potted plants on the footpaths. They have occupied, some people have grown trees on the footpaths. So some people have their guards sitting on the footpaths. Some people have parked their cars on the footpaths, right? And last year on 2nd September, Supreme Court passed an order that all these encroachments will be removed. And the next week, local vendors contacted me saying that the municipal corporation has pasted a written notice all over in the market telling the vendors to evict as per the Supreme Court order dated 2nd of September. So that order, I did a quick Control F for the soft copy of the order to see whether it mentions street vendors. It didn't mention the word street vendor. It didn't mention the word hawker, right? The order was specifically for this kind of encroachment, for security guard cabins, for potted plants, and for car parking, specifically against households, specifically against commercial, property owners. A municipal corporation did not issue a single notice to my knowledge to any of the house owners, at least in my locality. 000 compliance. But the first thing it did was to issue notice to all the vendors here. Of course, then we wrote letters to the municipal corporation and to the police with a copy of the order, and because it went from a lawyer, then of course they didn't take any action. But this is what happens. Now look at the model. So it's not that the car parking is not regulated. In fact, in Delhi, municipal corporation regulates car parking at least in the commercial markets. So how it does that is it outsources. So first it has an inventory of how many slots of car parking it has in a given space, and then it would auction that space to a contractor, and then the contractor can employ its people who would issue you tickets, who would charge you per hour. So for example, let's say in Hoskas market, the car parking rate is 10 rupees per hour. Connaught Place, it could be 50 rupees per hour, right? In other markets, it could be 20 rupees per hour. Now you see, there is no committee of car owners to decide how many slots, where car parking slot is, how will they get the, which space will they get, where will they park their car and things like that. It's not decided by a committee. It's decided, it's an agency model. So the municipal corporation is outsourcing car parking to an external contractor who is charging per hour. And mind you, so street vendors are not averse to paying fee. In fact, they pay much more, money informally and illegally to other stakeholders. And if the municipal corporation, and this was one of the questions that, why are they not charging money? Why is the government not charging money? Because government officials are earning money, not the government. So I've spoken to many vendors in different localities. Of course, the hafta varies. In some localities it can be lower, some other localities it can be higher. So they pay, for example, 1,500 rupees to 3,000 rupees to municipal corporation and to police, and also to the shopkeeper right nearby or the opposite, where they sit. So they pay to 3 people sometimes, right? Shopkeeper, of course, charges very high depending on which market they are in. And it's kind of a money to keep your mouth shut. So the shopkeeper will not complain as long as he's getting the money, because otherwise he can complain and get him evicted. The police, so similar situation, of 1955 of that Kolkata case, Sudhir Kumar Banerjee, that the police did not act on the vendors because, of course, I know here, for example, the police has taken money in lakhs, as much as 2 lakh rupees from a vendor to make him sit next to a government office, right? Government officer, if you conduct a survey, if you roughly see where are vendors sitting, usually they would be sitting right outside a government office or a government building. So for example, in Gautam Nagar, near our office, there are 50 to 100 vendors. They are all sitting on the back wall of AIIMS, All India Medical Institute of Sciences, right? So MCD office, there are vendors. The pumping station, the MCD pumping station, outside that there are vendors. And, at one such spot, the police took 2 lakh rupees to allow a vendor to sit there, right? And after this law has passed, not that because of the law the situation has changed, the police has become liberal in taking bribes and allowing the vendors to occupy spaces. I am not too sure the bribery has come down though. Anyways, so I compared it to the car parking model. So car parking model, there is no committee. there is no stakeholder, there is no election to be conducted, but it works well, right? Of course, we can argue, there can be a debate, how much money it should charge, whether it's a market-driven price or a politically negotiated price. But apart from that, the model works quite well. Okay. Third thing, do you think this law would be implemented? Now, we are tracking the implementation of this law for last 3 years, and we see that the most important point, the most important mandate of this law, that thou shalt not evict any vendor unless you have conducted a survey. So municipal corporation has to form a town vending committee. The town vending committee will conduct a survey. The survey, after the survey, you have to make a voter list. They will vote and form a town vending committee. And based on that survey, right, those vendors will get licenses, which is called certificate of vending, and they will get ID cards. So there would be some sort of allocation after that. Now, the problem is, it's a very, very complicated and elaborated procedure. Why? Because you are dependent first on the state government, because under the law, the state government has to frame rules and a scheme, right, within 6 months and within 1 year, which I think no state government did within that time frame. They did it very late because there is no, again, accountability. What if they don't do it? Nothing. The law prescribes nothing if they don't do it, number one. Number two, they're supposed to conduct a survey. What if the municipal corporation doesn't conduct a survey? Number one. Okay. What if the town vending committee, some provisional town vending committee or town vending committee under the national policy of 2009, if it doesn't conduct a survey, then what happens? Nothing, right? There is no penalty, there is no incentive, there is no fine, or there is no... So basically, what is the accountability of those state bodies? What is the accountability of those state institutions for not implementing the law? There is nothing like that. No checks and balances, right? And if the government officials are earning money through bribes and extortion, or of that some sort of mechanism, then why would they take the pain to conduct a survey or to call meetings of town vending committees and formalize the vendors? Why would they do that? Very, very unlikely that they will do that, right? So this is not surprising that most of the urban local bodies had not constituted their town vending committees, number one. Number two, even if the TVCs, even if this committee has been constituted, their meetings are not taking place, right? Their meetings are just not taking place. They have not been able to come to a decision. They have not been able to execute or implement the law. And this is not working out in most cities and towns. Okay. Now we come to zoning. So another feature of this law is basically the town vending committee also has to recommend to the local authority, to the municipal corporation, which zones will be no vending zones, which zones will be vending zones. And once a zone has been declared as a no vending zones, vendors from that zone will be relocated to vending zones. What is a no vending zone? This is very problematic. So, the traditional understanding is, well, how can you have vendors next to Rashtrapati Bhavan, right? How can you have vendors outside the parliament? How can you have vendors next to an airport? But I would say this is a flawed understanding. You see, there are vendors all over. You cannot not have vendors anywhere. Are there vendors in the Supreme Court premise? There are vendors in the Supreme Court. In the Supreme Court corridor, there is one person who sells lawyers' band to the lawyers, who sells pens and stationery to the lawyers. Right below the court number 1, so court number 1, you have to climb stairs to go to court number 1. Right below, there is a canteen, and the canteen has vendors. That's a vendor, right? In the Supreme Court premise, there are other shops and vendors, right? Outside the Supreme Court, there are vendors, right? In the High Court, there are kiosks, there are vendors. You must have heard about this famous chartwala right behind UPSC, right? World famous chartwala right behind UPSC. And outside Rashtrapati Bhavan, when you go there at 10 o'clock in the night, you will find, of course, not now during COVID times, but otherwise you will find hundreds of ice cream wallas in and around, around this India Gate area. There are vendors all over. How can you say that, you can't have vendors? Airport, inside the airport, there are vendors. Of course, those are, sophisticated vendors, but they don't own airport, by the way. They have no ownership over the space. They also are there, so they have been called, the kiosk is on rent and they own kiosks. There are kiosks and there are shops, but there are kiosks as well. So you have vendors everywhere. It's not possible to not have vendors because, for example, even in the Lutyens Delhi zone, which is, a VIP area, but you have government offices and you have thousands of government employees working there. So where would they buy their fruits and juice and cigarettes and, what you have in the afternoon? So they have to depend on vendors. So you cannot not have vendors, right? This is a very flawed understanding. So of course you can say that we cannot have more than this vendor, or the number has to be limited or whatever. But the understanding that you can't have vendors, I don't think so. That's a very rational way to look at. I think the whole prism of looking at street vending in terms of vending zone and no vending zone is flawed. Okay, next thing is so the law applies to the whole country. But if I looked at, when I looked at the cases, and after the law was passed after 2014, we looked at some of the cases, all high court cases. We wanted to see what kind of cases are coming to the high courts, for example, between 2017 and 18. So we looked at around, I think, for a duration of 18 months, and we looked at all the cases. So around 56 or 57 cases that landed up or decided by the High Court, in fact. So we looked at the judgments. And we found that most of the cases were still about eviction. So the evictions were taking place. The law was very, very clear that until you conduct a survey, you cannot evict, right? And many states had not conducted a survey, had not formed a TBC, but the evictions continued, right? The other thing that the law said, there's something called as natural market in the law. The law says any market which has been there for more than 50 years is heritage market, and otherwise where vendors and customers naturally congregate, that's a natural market. So natural market can't be evicted, can't be relocated. Heritage markets for sure can't be evicted. There's some markets. So for example, Daryaganj book market, which has been there for more than 50 years, is a heritage market. So you can't relocate that market. And you see Delhi High Court gave the decision to relocate that market, right? Delhi High Court passed, I think, 24 judgments. Majority of the judgments, I think 40 judgments were from Delhi High Court, and most judgments it held against the vendors. It said if a vendor has not been counted by those Supreme Court committees, so Thareja committee, then there was a Chopra committee, then there was another committee, and those committees must have counted few hundred vendors, okay? But Delhi probably has maybe 100,000, so maybe 1 or 2 lakh vendors, depending on whether you are a stationary vendor or mobile vendors. I'm sure the number exceeds 2 lakh, but even if the stationary vendor you look at, it would be not less than 1 lakh vendors, right? So according to High Court, only those vendors can be called as vendors who were counted by those Thareja and Chopra committees back in 1991 or 96 or 2007 or something like that, right? And so High Court judgments are actually, it's very, very problematic, but it was in conflict with this 2014 law and also the Daryaganj judgment, right? It relocated Daryaganj book vendors, the book market, to another place, but it was a heritage market, right? This is one thing. The other thing is, what I wanted to say is, so evictions hasn't stopped, and evictions have continued. So the law hasn't been able to protect the vendors. Why? Because there is no check and balance on the police and no check and balance on the municipal corporation. So what happens? So the law says very clearly that you cannot evict vendors. But if you do, then what? Right? So if the vendor breaches does any violation or breaches any duty, then you have fines for the vendor. right? You can penalize the vendor. You can suspend his license. You can evict him. What if the government municipal official, does something like that, or does not comply with the law, or breaches the law, or extorts the vendors, or harasses the vendor? What if the police harasses the vendor? Then where is the penalty on the police? Where is the any action that you can take against the police? No action. All the way, then again you will have to go to the High Court or Supreme Court, and they will also not listen to you. The record has been really, really bad. They haven't really been ever come to the rescue of the vendors. Never, not even in 1983 and not in 2020, right? That thing has not worked. So there is no accountability of the executive, or of course not of the judiciary. The concept is absent. But even of the public officials, there is no accountability, no check and balance in the law. So the law, it says grant things, but if those are not complied with, well, the law doesn't say doesn't provide any remedy. There are rights without a remedy. Okay. Now, we see that most cases that landed up in Supreme Court until 2014 most of the cases were from Delhi and Mumbai. Post 2014, we see some cases are from Delhi, Mumbai, and from other states, but not from all the states. So it seems that some states do not really have that kind of conflict among those stakeholders with respect to public spaces. Within Delhi also. So for example, Daryaganj has a conflict. Lajpat Nagar has a huge conflict between shopkeepers and vendors, right? For example, other places may have conflicts between pedestrians or vendors and shopkeepers, vendors and municipal corporation, but not all spaces, right? For example, Dwarika, is there a conflict between vendors and shopkeepers or vendors and consumers? Probably not, right? But the law mandatorily applies to all cities, all towns, all localities. But if there is no problem, then why do you have to conduct elections? Why do you have to, do all of that complicated procedure? You just let them be. And there was one study done in the US, and I'll request Shorjo or Anas to share that paper with you, and you can go through that paper. Basically, the researcher did an empirical study, compared two vending zones. One was an informal vending zone right across the road, and one was a formalized vending zone, right? And he compared the cost of formalization. The cost was really, really huge cost, because the government had engaged an NGO to have some sort of stakeholder consultation and arrange them into rows and do an allocation and all of that. And across the road, there was just informal vendors. How do they allocate those spaces and spots? Do they fight? And he found out that actually, there were no fights among those vendors. There was a very clear understanding of property rights. They respected each other's property rights. So there were two kinds of vendors. Some vendors who had been coming and occupying spots for a very long time. So they were long use vendors. And no other, not even new vendors, disturbed their property rights. And there were some vendors who were ad hoc, who were there for some short term, or who sometimes would come and sometimes wouldn't come. And so for them, it was first come, first serve basis. So if they come, they will occupy whatever space is available, but they would not occupy the long use vendor spots, right? So there was some kind of spontaneous order in the informal vending space, right? So if there is spontaneous order, why do you need to regulate? Because the regulation has huge cost. You are telling municipal corporation to hold elections, to do a survey, to do X, to do Y, and to do Z, right? Do you really need to do that? And what kind of cost it would result in, right? On the other hand, you just ask them. So like the car parking model, you issue them parchi and ask them for 20 rupees an hour, 50 rupees, whatever money. You will get money, but don't bother about, who is where and what not. You don't have to get into all that, right? So, this is about whether we really needed a Street Vendor Act for all the spaces, or probably we just needed some resolution for the spaces that were prone to spatial conflict, right? Okay. So with that, I am now open to questions.
Okay, I'll just share the screen, Prashant. Yeah, so we also have like questions that have been voted. So 3 votes for the first one, 3 votes for the second one, and then
Okay. So first question. Are the bylaws and relevant schemes advantageous to the independence of hawkers? If not, what can the public at large do to ensure their rights? Okay. I am not really in favor of. So there are two things. People say we need to formalize. We need to formalize. I said no. This is not about formalization of vendors. It's about public officials' accountability. Right. The problem is not with vendors so much so. The problem is with extortion and harassment, and that problem is related to police and the Police Act of 1861. So we have 150 years old legislation that governs police. We need to reform that, right? So if you also remember Nirbhaya rape case, I'm going slightly digressing. The problem is not death penalty. The problem is about policing. The problem is about police accountability, right? So whether it's criminal justice or whether it's about your municipal regulation, the police is deeply involved. So you see what happened in 1955 in Sudhir Kumar Banerjee. The police was probably taking money. Otherwise, what is police? The incentive of the police to let those refugees sit there, right? I mean, the police defied the commissioner of corporation to not just allow the vendors to sit there, but also not even respond to the commissioner of police, right? So this is about public accountability of public officials, and not so much about vendors. Okay. Next question is, how does one achieve a balance between street vendors' right to vent and residents' right to have a clean and walkable street, right? Okay. So I think first thing is subsidiarity. The problem is, who is managing our streets? Who is managing our public spaces? In Delhi, there are two bodies to manage public spaces. One is DDA, Delhi Development Authority. So for example, there are parks near my area that are managed, maintained by the Delhi Development Authority. And Delhi Development Authority is basically a bureaucratic body which works under the central government, the federal government. It's not accountable to Delhi government. It's not accountable to the municipal corporation. It's not even accountable to my local MLA. And therefore, for example, in 2014 or then in 2019, you voted for central government, right, for the parliament elections. So now you are probably dependent on your MP to kind of make DD accountable, which is a very, very loose link. There is no way that you can make the DD accountable, right? Very problematic. Then there are streets which are managed by municipal corporation. Municipal corporation is again a Babu body, right? And municipal corporations, for example, there are in South Delhi Municipal Corporation, which governs my area. It governs West Delhi as well as South Delhi. So the population under this municipal corporation must be 6 to 7 million or more than that. How do you expect this municipal corporation babus to be accountable to me, right? So there are problems. Of course, then at least it's better than DDA because you have your local councillor to ensure some sort of accountability. But the system is not really good. You have to have some sort of, you really need to take it further down, further lower level, to either something like an RWA, so Mohalla Sabha, but we haven't implemented 74th Amendment in Delhi to that extent, Ward Sabha, Mohalla Sabha, and so on, like that. Only then we can be able to ensure that the streets are walkable and they are in the interest of residents. What about rights of vendors? Vendors' right will automatically be protected once you have clarity in allocation of rights, right? The problem is not that the vendors don't have spaces. The problem is uncertainty. Once you have clear property rights, then automatically it would be clear. And also, it works both ways. So it's not that the vendors need people. People need vendors and therefore the vendors are there. I can give you example of my RWA. my RWA secretary, the RWA body, the managing body, sought to limit vendors' movement in our mohalla, in our street, right? And number of residents and women raised their voices against this decision. Then how can you decide that? And no wonder, the whole managing body were, that it only had males, only had men in the managing body. And the women raised their voices that you haven't consulted us and you don't even care, because we need vendors to buy vegetables every day. You don't buy vegetables, and it's a very, very gender-centric view you are taking. You are not thinking about us, but it's a very self-centered decision, right? So people need vendors. They want vendors in their localities, right? Okay. I have witnessed police evicting the street vendors in area Bangalore. Then they had moved into the side streets. Is that act of eviction legal? Most likely not. And I've also seen that in Bangalore once I was there and having Nariyal Pani, and the traffic police guys came. I in the local language, they went on for 15 minutes almost, scolding the vendor and harassing him. And after that, the vendor gave them free Nariyal Pani to both of them, and then they went up, right? Evictions are legal or not? Most likely evictions are not legal, because the law is very, very clear. You can't evict unless you have done a survey and constituted town vending committees, given certificate of licenses, certificate of vending, and so on and so forth. And even then, the eviction, there is a due process to follow for the eviction, and eviction is not easy. It has to be relocation, so they will be relocated to another area if there is, the previous space is to be considered as a no vending zone, or for some public purpose, it has to be taken over by the municipal corporation. So eviction is not easy, and most likely it must have been illegal. The problem is, what is the recourse? And so therefore, vendors are unable to raise their voices. Okay, next. Street vendors surprisingly isn't organized in the formal tax structure. So yes, I covered this question. Government can earn huge revenue, and street vendors would be more than happy to pay money if they can feel secure and safe and certain about, stable about this legality. The problem is they pay money informally to the municipal officials, they pay money informally to the police, they pay money to the shopkeeper, and still the municipal corporation or the committee van comes and takes away their stuff. Despite paying money, there is no security. And even after the law is passed, there is no sense of security. Okay, next question. TVC is empowered to regulate vending spaces. Also, municipal bodies issues licenses. How do these two really interact with each other in this setup? So no, in the new setup, TVC is empowered to also issue licenses and not municipal bodies, right? Municipal bodies are responsible to do zoning at the recommendation of TVC. But TVC is responsible to conduct surveys, to issue certificate of licenses, certificate of vending. And so TVC has a lot of functions, but TVC is housed mostly under the municipal body, and the municipal commissioner is the chairperson of the TVC. Next question. Why can't we encourage huge unemployed youths to tap this segment either in a standalone or fleet of vendors guaranteeing standard quality and feel across? So, a lot of people say we need to organize vendors, we need to train vendors, and the government also. So exactly same in auto rickshaw sector, but I shouldn't digress. But for street vendors, government has been coming up with trainings, okay, coming up with ideas. How do we ensure quality? The problem is you have constrained and constricted this sector. You don't let investment flow in street vending, right? You love to keep vendors poor, right? You love poverty so much that you can't see vendors becoming rich. And there are legal barriers, restricting vendors from becoming rich. So for example, there is one condition that the street vendor, to become a street vendor, you must prove that you have no alternative livelihood, which means if a person has another livelihood and has investment, he can't become street vendor. So I got a call from 3 management students of an MBA college saying that we want to put up a food truck. What is the regulation? Of course, the regulation is very, very ambiguous. Still, things are not in place. That's a problem. But they will have to give that in on an affidavit that they don't have an alternative employment. I think maybe in their case it's not a problem, but we are so accustomed to imagining street vendor as someone with torn clothes, with a dhoti, and we have stereotypes of street vendor as someone who is really, really poor and needy. But many of the street vendors are not, I sold my last car to a street vendor. I mean, this stereotype the street vendors are by default poor, that's not true. Although the government is trying to keep them poor, the law tries to keep them poor. And this is why most of them don't comply with the law, right? Anyways, so not just that. So first barrier is that they can't have alternative source of employment. Number 2 is that they can't expand their business. So they can't have another vending spot, right? They can't expand their business. The idea is a very, thing that one person one vending spot, right? But you see this restriction, and I discussed it, and some of you were there for yesterday's iPolicy session, that no shopkeeper. So shopkeepers can have multiple shops, industrialists can have multiple, industries. They can have as many factories there as they can own. The airlines can have as many aeroplanes as they want to have. So then why this restriction on the vendors to have only one vending spot? Why can't they expand their business? This is problematic. Okay. The term street vendor differ from the vendors in airport. Does Act 2014 applicable to street vendors occupying public road include such vendors in airport? The Act does have a provision about vending in private spaces, although I don't think so. The Act has got it very clear, and it is very clear in terms of what it wants to do with vendors in private spaces. So, for example, people who are from some of you who are from Delhi would know Select City Walk, the mall in Saket, holds a weekly flea market every Wednesday. Right? Usually Wednesdays have low footfall, and so they hold a flea market. Right? Flea market would mean that the vendors come. Right? Vendors put up their kiosks, and they come every Wednesday, and they pay money, for those hours to the mall management. They're vendors in a private space. So the law has that kind of some provision, but the provision isn't very clear what it wants to achieve. I mean, what kind of regulation and why it wants to regulate. Okay. If not the Act, what would be probable statutory reforms to ensure vendors' right to livelihoods? So, for example, what is the law to govern car parking? Right? Is there a law to govern car parking? Is done under the Municipal Corporation Act. Just that we need smart governance. We need smart laws. We need laws that align incentives of various stakeholders. Right? It's not so much about statutory reforms. I think it's more about governance reforms. We really need to think in terms of incentives and how to align incentives to come to an efficient outcome. Right? We would be better off without this law, I think.
Prashant, we can take one more question.
Okay, so this is the last question. It's already 6:29. Can any provisions of mixed use regulation provided under Master Development Plan for Delhi be used by street vendors to access their rights? I am not aware of, at the moment, I am not very sure about mixed use regulation, what these regulations are and how do they interact with the street vending regulation. So I can't say, but mixed use, I am a big advocate of mixed use. They should be mixed use, not just for vendors, for shops also. Okay. If street vendors are vending on public streets or areas, why is there still a need for clear property rights for them to carry out their activities? Property rights, as in, so property right doesn't mean that they own the property. Property right would mean that if they own, suppose if they have a license to vend at a particular spot, that should be very clear that this is what their license says. So if the license says, you have the right to vent at this spot for so many hours, then during that time, there should be absolutely no harassment or extortion. And if that happens, there has to be a clear remedy. Okay, some action has to be taken against the aggressor or the person who violates that. So, for example, there are weekly markets in Delhi, right? So, for example, in West Patanagar, there is Shukar Bazaar. Every Friday, thousands, hundreds, I think thousands maybe, of vendors congregate, let's say 7 o'clock in the evening to 10 o'clock in the night, and they sell their stuff, right? Once I happened to ask one of the persons who organizes it, so they get those tent house tables in, so the lot of trucks come Friday evening to distribute those tent house tables, and Saturday early morning before the sunrise, trucks again come to pick up those tables, right? And the person, the vendor leader who organizes all of this, I asked him that what is, how do you get a spot here? How, if you want to enter into that market as a business person, as an entrepreneur, how do you get a spot? So he told me that it would take 75,000 rupees, and he would put me in touch with someone who wants to exit that market, right? Who no longer wants to do that business. So imagine there is no patta, there is no paper, there is no documentation, and there is no title. Yet there are informal property rights, right? Informally, they recognize, they acknowledge each other's property rights, that they are willing to sell and buy the right to vent for 4 hours every Friday in perpetuity, right? There is no ownership, but there is that right which is tradable. Isn't that amazing, right? This is informal institution, some sort of spontaneous order. Okay, so with that, I rest here. I stop here. It's already 2 minutes over. But I'm happy to take your questions in, maybe either on Twitter or through email, whatever Shojo or Anas suggest. I think email is also fine with me. So you can forward your questions. Or if there is a WhatsApp group, I'm happy to post answers there. Thank you.
Thank you so much, Prashant. It was a very, very eye-opening as well as sometimes disturbing to learn about, how the law has actually worked against these people. But this was a fantastic eBaithak. I'd like everybody to, put in their feedback. We've given a feedback link in the chat. And just to announce, our next eBaithak will be on the 15th of May at 7 p.m. at Catherine Semser on environmentalism. We'll get back to you with the exact topic, but Catherine Semser is a research fellow with PERC in the US. Thank you so much, and have a nice evening.